We are continuing on the Corporate Transparency Act. We're continuing on the information regarding the Corporate Transparency Act. This is video 3. If you have not reviewed video 1 and 2, I highly encourage you to do it to better follow along. Video 1 talks about what the Corporate Transparency Act is, why it was enacted and come into play, and what is required or what developed out of that enactment. Video 2 goes over some keywords that are used when we're talking about the Corporate Transparency Act. You'll hear a lot of abbreviations when we talk about the Corporate Transparency Act, and you want to know what these abbreviations mean. So video 2 goes into those key identifiers and let you know what those words mean, whether they're abbreviated or not. If they're thrown out, what do they mean? And so today what we're going to talk about is, does your company have to report? And I touched on this a little bit in the previous 2 videos, is that when you hear individuals talk about the Corporate Transparency Act, they usually just identify LLCs. Well, if you listen to video 1 and 2, then you know this applies to more than just an LLC. But what I want to talk about in this video, when I talk about does your company have to report, is talk about the 23 exempt companies. And if your company falls under one of these 23 exempt companies, then you will not have to report a BOI as a reporting company. The thing to be very careful about these 23 exemptions is that when these exemptions are listed, the Corporate Transparency Act also lists how to qualify for that exemption. And in the language that identifies if you qualify or not, it's used if all of this apply, any of it apply, either apply, both apply. So you have to look at those key identifiers. Just to give you an example, there are some exemptions that are listed. Let's just use inactive companies. That's one of the exemptions. If the company is inactive, then you will have an exemption. However, the measurement of determining if your company is inactive have these 2 requirements, and it says all apply, or 4 requirements, and it says all of these have to apply, not just one, but all. Then there's some exemptions that may say any apply. So that means it could be, if you have 4 things listed, it could be any of them. Either apply or both apply. So you really have to see the identifiers, the measurements of what's going to be deemed applicable to you with these exemptions. All right, so there's 23 exemptions. You have exemptions for securities reporting issuers, governmental authority, you have the bank, you have state or federal credit union, depository institutions like holding companies. You have money services businesses, broker dealer in securities. You have the Securities Exchange or Clearing Agency. You have other Exchange Acts registered entities. You have investment or investment advisor, so an investment company or an investment advisor. You have venture capital fund advisor, insurance company, state licensed insurance producer, Commodity Act registered entity, an accounting firm, public utility, financial market utility, pooled investment vehicle, a tax-exempt entity, entities assisting a tax-exempt entity. And again, because a lot of individuals may say, well, I assist a tax-exempt entity. You have to read what the Corporate Transparency Act is, or hire someone who understands it to explain to you what the Corporate Transparency Act is deeming as an entity that assists a tax-exempt entity. And it usually states an entity that operates exclusively to provide assistance to exempt entities. Entity that is owned or controlled exclusively by one or more U.S. persons that are U.S. citizens or lawfully admitted for permanent residence. The entity has to derive at least a majority of its funding or revenue from one or more U.S. persons that's a citizen or lawfully permitted to reside in the U.S. So you have all of those things that have to apply. And when you're looking at all, if you only can check one, but you say that you would assist a tax exempt entity, then the exemption would apply. So I wanted to point that out when I just talked about earlier, where there's actual measurements to see if you qualify for the exemption. You may qualify in your mind by stating that you are something, but then you have to look at what the law says that they determine if you are that. Large operating companies, and when they say large operating companies, they're talking about companies that employ 20 full-time employees. You have to be employed, they have to be employed in the U.S., and the entity has to file a federal income tax demonstrating more than $5 million in gross receipts. So all of those things have to apply. So say if you're looking at if you are an exempt company, and just use this right here, the most recent thing that I talked about. You decide, okay, I'm a large operating company. According to what they say, I employ more than 20 full-time employees employed in the U.S. The entity files a federal income tax that demonstrates $5 million in gross. If you exempt at one time and any of these criteria change, you now fall out of being an exempt company, and you have to update that on your report, and then you now become a reporting company, and you have a certain amount of time to do that. So I wanted to point that out as well. You can be exempt at one point, but anytime you do not meet the criteria for that exemption in which you say applies to you, then you're no longer exempt, and then you need to report as such. All right, a subsidiary of certain exempt entities, and as I stated earlier, in an active entity. And within active entity, all six, it's actually six, not four, all six criteria must apply. You must be an entity that was in existence on or before January 1, 2020. So the general understanding of an inactive company would just be, I don't do business anymore. I formed that company. I don't do business with that company. I'm not doing anything. It's been inactive. I heard that an inactive entity is one of the 23 exemptions, fall under one of the 23 exemptions, so I'm exempt. But no, it's not that you just don't do business anymore. Your company had to be formed on or before January 1st, 2020. That's the first criteria to meet. If you don't even meet that, if your company was formed after January 1st, 2020, then even if you're not doing business, you're not. You need to report what you need to report. But if that does fall into play, then you have to look at if the entity is not engaged in any active business. If you check that box, you'd be like, yes, no, it's not engaged in any active business. Now you have to look at the entity is not owned by a foreign person. You check that box. You can't be owned by a foreign person directly, indirectly, wholly, or partially. So not owned at all. There's no changes in ownership in the preceding 12 months, so if nothing been done. So you just keep going down the list and check all six off. If all six check off, then you may fall under being an exempt entity. Exempt entity as an inactive entity. But if they all six don't check, you have to stop anywhere on that line, then you're not considered an inactive entity, although you may not have been doing business. So what the take from this is, you have the 23 exemptions that apply. In those 23 exemptions, there are criteria for you to meet to say that you are that thing according to the Corporate Transparency Act. And if you are, and you are exempt, at any point, if any of the criteria changes in which apply to you that allowed you to be exempt, you now are no longer exempt. You have to update that information within the time frame that is needed. We'll get more into that. But those are the 23 exempt entities. If you do not fall under those 23, then you are a reporting company.